This is Josh Black reporting live from the 2009 Federalist Convention. I am sitting next to a living legend, Professor Richard Epstein of the University of Chicago and NYU Law School. How are you doing, sir?
I'm doing fine. A little noisy in the background, but you know, that's a Federalist Society.
How's the convention? Are you enjoying it so far?
I like being in sessions and I like talking to my friends, so what's not to like about the convention?
You had a couple good zingers in that panel with Andy Stern.
Yes.
Do you think you'll read your book?
I hope so.
Do you think you'll get a lot out of it?
I hope so.
I agree.
Look, I actually think he's an incredibly effective speaker. But I think that his technical grasp of his own subject is not there. And what typically happens with people like him who have to go into hostile audiences is if he can't feel comfortable with the technical issues, he'll talk about the vision thing. I mean, it is noticeable in this particular session not once did he mention the Employee Free Choice Act, right? What he did is he spoke in the language of aspiration and his adoration for capitalism and talked about the inequality of wealth, which many of his programs will actually exacerbate. But I thought it was extremely clever tactically, but I thought it was utterly unpersuasive intellectually.
So what do you think of the upcoming Supreme Court term, especially the McDonald case?
On the McDonald case, I mean, first of all, now that I remember what the name is, this is the question where the Chicago Police Department is dealing with the issue of the incorporation, if that's what it would be in the Second Amendment. And, you know, one of the things is when people start to think very hard about things like this, they realize is that the traditional structures don't work very well. And incorporation is not the operative mode with respect to privileges and immunities. Privileges or immunities in the 14th Amendment, rather, were essentially designed to give a list of enumerated rights or something of the sort. And it wasn't supposed to be by incorporation of the Bill of Rights. It was supposed to be by thinking of the things that were covered by the method. The incorporation of the Second Amendment does not work very well because, in my judgment, the Second Amendment, as originally drafted, was a complement to the militia clauses that appear in Article 1 of the Constitution, which regulate the state control of militia vis-a-vis the federal government. And I think what they were designed to do is to say that the federal government could not wipe out the state's ability to regulate guns. And if that's the case, it's not an incorporation issue at all. It's already a federalism issue. And trying to incorporate the Second Amendment into the rest of the Constitution doesn't make any sense if you've got the first Article 1 issues to deal with. So I don't see it as an incorporation issue. In fact, I wrote a little piece on this in the Syracuse Law Review, in which I said the only place to which the Second Amendment doesn't apply is the District of Columbia, because that's the only place where there's no state militia to defend, so that's an issue in which the problem of coordination of two branches of government doesn't arise. And the usual view is exactly the opposite, that it obviously applies there because we have a direct limitation on the federal government. But that's not what's at work there. It was a limitation on the federal government designed to preserve state autonomy. And so I thought that the discussion of Justice Scalia on the point was wrong, and there were a couple of places where Justice Stevens actually got it right. Because, you know, when the history tends to be in his favor, he's an excellent originalist. All these guys, to some extent, the birds of passage. If the originalism cuts their way, they like it, and if it doesn't, well, they tend to go on other grounds.
So do you think that they can actually strike down the Chicago ordinance without actually touching the Second Amendment, just have some ethereal, natural, common law right of self-defense?
Well, I don't think you can get there under that particular theory, because you're going to then have to worry about the standard of scrutiny that's going to be given. And the argument is, are you striking down the self-defense right by meaning that people can't own guns, or are you making it unnecessary for people to have a self-defense right by getting out of the hands of the aggressors? There's a large empirical literature on this, which basically comes to a standstill on whether or not the various kinds of gun control regulations are or are not conducive to greater or lesser safety. And sometimes you get adjacent states which point in the opposite direction, which means that there's a lot we don't understand about this. The one thing that was clear about the Scalia decision was that if the Second Amendment in some sense does apply to the states, then it's clear that the rational basis test is not going to be sufficient. They'll have to show more. And in New York, for example, the panel that dealt with the Nunchukos was very casual on all these issues, never really addressed
That was Judge Sotomayor.
Yes, so she was on the panel, but it was basically it was a very kind of back-of-the-hand treatment. The only serious treatment on this issue was the one that Judge O'Scanlan gave out in the Ninth Circuit. Judge Easterbrook essentially took a deferential line and then made a number of arguments against incorporation, none of which is particularly persuasive.
Okay,
What's the other one? Oh, about the Hillary. Oh, I know about that case. Look, I mean, my view about this is one of the truly calamitous decisions in recent years was essentially the McConnell case, which abstained the a nonpartisan review bill. The reason it was nonpartisan is that all incumbents were in favor of protection. I thought that was a case in which there was a particularly strong Scalia dissent, and that I think the whole thing should be struck down in root and branch. It takes a genuine genius to come up with the conclusion that the speech which is most germane to election, closest to election time, is that which receives the least constitutional protection. And the theory of the First Amendment was that I can speak and you can speak in competition to me, and the thought that on the basis of no empirical information you can try to resort to a planned economy through the Federal Elections Commission struck me as a giant-sized mistake. One of the really pathetic features of the O'Connor-Stevens opinion is when they were trying to find systematic abuses that were not caught by all the elaborate set of laws that were already in place. They could find one dairy case from many years ago. I can show you congressional statutes which stink to the nostrils passed in recent times, where it's not the election that matters, it's the lobbying that matters with respect to Congress, which essentially are just indefensible. So if this is the worst that they can do on elections, they shouldn't do anything. What they really have to worry about is the way in which the whole lobbying process works. And the short answer to that is they have a very weak system of property rights because of what they've done under the takings clause. And they also have a huge expansion of government scope because of what they did under the Commerce Clause. And the danger that you have with regulation is that there's no constraint on what these guys can trade off on one issue against another, which means that money will pour into Washington. The central theorem is when property rights are indefinite or unknown, there will be huge amounts of money made to sort of drive them in your direction. It's one that we should never forget. It pervades all areas from patent law on down. And until they basically go back to a sense where property rights are dense as opposed to simply being the right to exclude, this problem will not be eliminated.
All right, Professor Epstein, how are you enjoying your time at NYU now?
I enjoy my time at NYU, I enjoy my time at Chicago, I enjoy my time at the Hoover Institution. I regard myself as one lucky guy who's been affiliated with 3 wonderful institutions.
And I am very lucky for this interview. Thank you so much, sir.
Okay, I hope it helps.